Good day, everyone. My name is Pedro Villarreal. I'm a senior research fellow at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg, Germany. And thank you for joining me today in this presentation addressing last week's World Health Assembly special session dealing with a potential new legal instrument on pandemic preparedness and response, among other things, as we will see today. I will proceed to share my screen as I have prepared a PowerPoint presentation. And in this World Health Assembly special session, one decision was adopted by consensus, which I will discuss with you today. And a lawmaking process, an international lawmaking process, was triggered, which will lead to a series of steps that will hopefully, for those that were proposing it, could lead to a new treaty or other legal instrument in the field of pandemics. And I'm aware that by this point, you might be overwhelmed with information related to the pandemic and international law already. So today I will limit myself to discussing what this potential lawmaking process may look like. I have on purpose put aside the more substantive issues, because as you will see, the procedural matters and the steps that might lead to this lawmaking are already considerably complex. So in this World Health Assembly special session, what happened then? And the special session took place in a hybrid format, as it is quite clear that receiving representatives or delegates of all of the member states of the WHO, which are 194 physically in Geneva, would have constituted a potential super spreader event in light of the COVID-19 pandemic. And therefore, these negotiations and the session itself took place with the online participation of multiple representatives of governments, including heads of state and heads of government and different ministers of the WHO member states. And between the 29th of November and the 1st of December of 2021, this hybrid session led to the adoption of a decision. And being a World Health Assembly decision, it will then trigger a process of different negotiations. But what is then the World Health Assembly as such? Well, it is the WHO's principal decision-making body. It is the body within the organization capable of adopting resolutions and decisions, some of which, and particularly some resolutions, may lead to legally binding acts for all WHO member states. But in itself, it is a meeting of all of the representatives of the World Health Organization member states, 194, those that are able to make it to the meeting anyway. And on the left, you see what the usual meetings look like in Geneva, but considering the pandemic situation, of course, we now see on the right that these meetings take place in a hybrid format with a number of persons being physically present at the World Health Organization, but most of the governmental representatives participating online. And it is a yearly meeting, and which usually takes place in Geneva in May, usually, but exceptionally it has special sessions whenever there are matters that require particular attention and are not addressed in the quote-unquote ordinary yearly meetings of the World Health Assembly. And on the 1st of December, so on the last day of this special session, one decision was approved by consensus. This decision was eloquently entitled "The World Together," and it consists of the establishment of an intergovernmental negotiating body, which will be the one tasked with preparing a potential draft for a new legal instrument on pandemic prevention, preparedness, and response. However, as we will see, the decision included also other items that could indicate different paths being taken in the upcoming negotiations. Because as we all know, the outcome of these negotiations can never be taken for granted. Many things can happen. It is a convoluted political process with bargaining and negotiations on very difficult issues, which again, I decided to leave out of today's presentation because they are manifold, and I would not do any justice to the depth and the complexities of such substantive matters that are the ones leading to heated debates at all levels of society. And according to this decision adopted at the World Health Assembly, 3 paths so far have been envisaged. The first one is to amend the International Health Regulations of 2005, which is currently the core legal instrument in the field of the cross-border spread of disease, not just focus on pandemics, but on all disease-related events that may have an international dimension, so a potential for a cross-border spread, and that require an international coordinated response. But in the decision, it was also established that the adoption of a convention or other legal instrument in the field of pandemics should also be part of this negotiation and will also be the mandate of this intergovernmental negotiating body, the IMB. The exact type of instrument is to be decided on in August 2022. So there is still time to make the ultimate decision of what type of legal instrument we are dealing with. And this will also depend, as I will explain in the upcoming slides, on what member states consider to be the most practical solution, considering the difficulties inherent in any creation of a new international law instrument. And lastly, as part of this open clause within the decision that the exact type of legal instrument is to be decided, soft law remains a fail-safe option in case no full consensus or not enough consensus can be reached in creating a new legally binding instrument on pandemic preparedness and response. Well, I will address these 3 paths briefly. The first one being the amendment of the International Health Regulations. So what is the process underlying such a path? The Constitution of the World Health Organization, which is itself a treaty, so it's called a constitution, but it is under international law, a treaty that had to be ratified by all of the current WHO member states in order for them to be members of the organization. The Constitution sets the possible terms for an amendment of the International Health Regulations and for a new legally binding instrument. So it sets the scene for what the members of what the delegates at the World Health Assembly may choose to do. And in terms of the International Health Regulations, Article 21 of the Constitution of the WHO grants the World Health Assembly the authority to adopt regulations concerning, among other things, sanitary and quarantine requirements and other procedures designed to prevent the international spread of disease. And this clearly is the case with COVID-19. And moreover, Article 22 of the Constitution stipulates that these regulations will come into force for all members after due notice has been given of their adoption by the Health Assembly, except for those members that may notify rejection or reservations within the period in the notice. And the notice is usually a provision within these regulations that clarifies how long this period will last. So to highlight this and to illustrate this further, these 2 provisions, namely, set out the following steps for having new regulations or amending existing ones. And the current regulations of 2005, adopted by the World Health Assembly in that year under Article 21 of the Constitution, they entered into force in 2007, 18 months after the approval at the World Health Assembly for all 194 member states, as well as the Holy See and Liechtenstein. These two are not WHO member states, but they may nevertheless exceed the regulations. So it is not closed to non-WHO member states. And again, these 18 months of duration between their approval and their entry into force can be decided by, in each regulation approved under Article 21. It is not set in the Constitution, but it is decided in one of the provisions of the corresponding regulations. And the way it looks like, broadly speaking, is the following. So after regulations are approved at the World Health Assembly, and actually there may also be approved by consensus, so without roll calls or taking up votes. And this also applies to amendments. So whenever these regulations are amended, these amendments can be approved, and then after a period stated in the notice, they will enter into force for all states parties of the regulations, not just the WHO member states, but also for the Holy See and Liechtenstein. This period of time determined in the regulations is 18 months. So once it elapses, the regulations enter into force for all of those member states that have not opted out. And the current version of these regulations are in force for all WHO member states, as none of them expressed any desire to reject them. And this is unlike previous versions of these regulations, which did have had historically experienced opt-outs by states that did not wish to be bound by them. So it is a possibility. It is not just a theoretical consideration. So much for the regulations, and this is the procedure for both approving and amending them. What about a new legal instrument, a new international law instrument on pandemics? What would this look like? And this would be different, as you know, besides the fact that the denomination is still up for negotiation, any new legal instrument would require then a legal basis, right? If it is one within the WHO, if it is one in the aegis of the WHO and not an open general treaty negotiated besides the WHO. And taking this into consideration, so insofar as there is no agreement yet on what type of legal instrument this will be, an intergovernmental negotiating body was created, and part of its mandate will be indeed to foster and to lead the negotiations between WHO member states. Its first meeting is scheduled to take place on the 1st of March of 2022. And it should reflect a balance between developed and developing countries, but this remains to be defined. Of course, this binary category encompasses countries with very different degrees of what is deemed to be economic development for the purposes of, you know, their of being representative of the different member states of the World Health Organization, and not just those from the global north that currently and in the past have led many of the negotiations of new legal instruments. And the first working draft of a legal text should be prepared and ready, presented no later than the 1st of August of 2022. And this includes deciding upon the exact legal basis of a new international law instrument on pandemic preparedness and response. So it may be frustrating, of course, for many of you to realize that this is still up for negotiation and this is still the subject of back and forth diplomatic considerations. But indeed, it is directly related to the complexities involved in the process of creating new law at the international level. Therefore, setting or determining the exact legal basis will have major implications for how these negotiations take place. And of course, they may lead to stalemates, which is one of the concerns of the World Health Assembly attendance, that indeed they may not be a sufficiently global acceptance of any potential new legal instrument in the field. As you can already imagine how many of the substantive issues that are to be debated are contested ones and are very controversial ones, as they lead to divides between the different WHO member states. And this will ultimately determine the chances of ever witnessing the creation of a new legal instrument with a sufficiently disseminated, with a sufficiently global degree of approval. And considering how pandemics are a global phenomenon, a global consensus is, of course, the ideal outcome, but the main challenge is how to achieve it. Moreover, the World Health Assembly, as similar to the regulations, has the power to approve these international conventions or agreements. The denomination does not make a difference here. But what makes a difference is what their legal basis in the Constitution is, in the Constitution of the World Health Organization. One of the avenues that is being discussed is Article 19 of the Constitution of the WHO, which grants the Assembly the authority to adopt conventions or agreements with respect to any matter within the competence of the organization. And here we see already a difference with Articles 21 and 22 of the Constitution, because Article 21, I only included the first topic, for which regulations may be approved. There are others, but Article 21 is considered to be a limited list of subject matters that may lead to the approval of regulations. So it is not an open list of subjects that may be addressed through regulations. And by contrast, Article 19 does have such an open clause. It refers to any matter within the competence of the organization. And the competence, as we may remember, is to be the coordinating authority in international health, which is a quite expansive topic. This then leads to the possibility to issue conventions or agreements in a wide number of areas. It is not, of course, an unlimited set of topics, as we have seen in the International Court of Justice's advisory opinion requested by the WHO on the legality of the use of nuclear weapons, which was rejected precisely because the International Court of Justice did not accept such an expansive reading of the World Health Organization mandate as including all of the areas of life that have to do with human health, which would, of course, include the use of nuclear weapons, considering their devastating effect on human lives and human health. But this, of course, this perspective that the WHO has in a very expansive mandate, considering how health touches upon so many aspects of our lives, this perspective has been rejected by the ICJ. And therefore, this provision should also be read considering this non-expansive reading of what international health encompasses. And as for the procedure, a 2/3 vote, for the procedure to approve these conventions or agreements within the WHO, a 2/3 vote of the Health Assembly will be required. And importantly, These conventions or agreements will come into force for each member when accepted by it in accordance with its constitutional processes. What does this mean? Basically, it means that in order for a member state to be bound by these conventions or agreements, they must undertake the full process as if it were any other treaty under their constitutional law or constitutional systems. So unlike the regulations, besides the approval by the World Health Assembly, conventions and agreements requires the approval of other national bodies when this is the case that are tasked with approving treaties in order for them to enter into force for all of these, for these member states in particular. It varies from state to state what that national body is that will approve whatever the delegates have signed at the World Health Assembly, and which will then lead to the country sending its instrument of ratification whenever that is required according to the constitutional processes of the country in question. And the only legal instrument ever adopted under Article 19 of the Constitution of the WHO, so despite the fact that this constitution has been in force already for more than 70 years, there have only been one legal instrument that was approved under this provision and with the procedures I mentioned, and that is the WHO Framework Convention on Tobacco Control. It has 182 states parties, all of which had to address the procedure I mentioned. They had to further approve or submit this legal instrument to their corresponding national bodies, which would then approve this framework convention and send their ratification instrument. And while 182 states parties is, of course, by any means a very impressive membership, a very impressive number of states parties to any international convention, we should note that this framework convention on tobacco control has major non-parties. For example, the United States of America, which is quite the non-party, considering that many of the negotiations were led by the United States and persons from the United States. And so it does stand out the fact that the USA, although being a leader in the area of global health and being a leader as well in the formation of this framework convention, is currently still not a state party to it. And it also, the list of non-states parties also includes Switzerland, which is the seat of the World Health Organization's headquarters. So you can imagine how these two very visible non-states parties are an example of what may happen in terms of the political risk involved in any new legal instrument that is approved and at the international level, but that must then, of course, be subjected to a procedure of ratification. And the way it looks like for these conventions is, in very summarized terms, the following. After a convention is approved at the World Health Assembly, it must then receive the subsequent approval by a national body if necessary. And again, this is established in every legal system, the procedure for approving new conventions, agreements, or treaties for that matter. And let us remember that in accordance to Article 2 of the Vienna Convention on the Law of Treaties, the denomination will not make a difference for them being considered as falling within the purview of the Vienna Convention on the Law of Treaties. And therefore, it is up to domestic legal systems to determine what the procedure for approving such legal instruments is, and which will be the body tasked with approving an international law instrument that was negotiated and signed by one of the representatives of that member state at whatever international fora we're dealing with. And therefore, we would then see the need for an approval by the multiple, usually it's the legislative bodies, but it's not always the case, by multiple national bodies, which will then discuss and potentially accept and approve such instruments in accordance with their own procedures to be bound by international law instruments. Again, this is quite different than the regulations, because only after this subsequent approval has been achieved will the convention or agreement or other legal instrument under Article 19 of the Constitution of the WHO enter into force for the particular member state at hand, or it may also be a non-WHO member state, as we saw with the Holy See and Liechtenstein in the case of the regulations. But as you may be aware of, many things can happen in the interim. Many things can happen in the process of securing the approval of these national bodies. And of course, this has historically led to major failures to secure the approval of these national bodies in multiple treaties. And this, again, will be a major debate in national political circles, insofar as the stakes that of the pandemic are so big that we can easily envisage very contentious aspects within different political groups of all of the countries that will have to approve and then ratify such a new convention or agreement. So to compare both the regulations and these new, a potential new agreement or convention, a new legal instrument would indeed have a broader reach than the international health regulations, since one of the examples of the substantive issues which I decided to put aside today for reasons of time is equitable global access to medical and public health countermeasures, which remains to be discussed in the ages of this intergovernmental negotiating body. This, again, is not currently envisaged, is not a topic that is included in the international health regulations, and it does beg the question of whether, considering the limited list of subject matters under Article 21 of the Constitution of the WHO, whether it would be possible at all to address such an issue within the regulations or within an amendment. This is, again, very unclear, and it depends on whether one has a restrictive or an expansive view, but the fact is that access to medical and public health countermeasures is not one of the topics included in the list of Article 21 of the Constitution of the WHO, and therefore a new legal instrument which has a more open formulation under Article 19 of the Constitution of the WHO could have such an item. Of course, let us remember that considering the fragmentation of international law, this will touch upon other legal regimes beyond that of the WHO and its own legal powers, and namely that if equitable global access to medical and public health countermeasures is to be negotiated upon at the international level, this will inevitably touch upon matters pertaining to the agreement on trade-related aspects of intellectual property rights, which falls under the purview of the World Trade Organization's law, including the General Agreement on Tariffs and Trade and all of the covered agreements under the WHO agreement. So as you can see, it is such issues are involved by multiple set of legal regimes that cannot all of them be addressed only through the WHO's legal regime. There are ways in which they can be addressed through the WHO, but it will not be exhaustive. Now, negotiating a convention, agreement, or other legal instrument could also guarantee more participation in the lawmaking process in comparison to the international health regulations. One of the rationales for granting the World Health Assembly such streamlined lawmaking powers to create new regulations is basically that they are viewed as having a mostly technical nature, and the delegates that participate in them and that have historically participated in them are usually experts in the medical and public health fields. And therefore, it was considered that, and taking into account the limited list that we see in Article 21, that those quote unquote technical issues, we may of course challenge this category, would then require the input by a series of experts and the delegates that often represent ministries of health and so on, rather than having the usual lawmaking process. But this again results in a limited participation, which can lead to questions of democratic legitimacy and how deeply they can go by, for example, sidelining national bodies that would guarantee at least having a deeper discussion and at the national level that is otherwise not provided for in Article 21 of the Constitution of the WHO, because the results of reforming and approving the reforms of these regulations will be that national legislative bodies, for instance, will not be involved in those discussions. This again has trade-offs. It has the pro that the lawmaking process is more streamlined, but it has, of course, the con that there is a lower degree of participation. It stands up for debate what model is preferred and why. But let us also keep in mind that for the same reason, consensus is much more difficult to achieve with a convention or other legal agreement, let alone the fact that it will take a much longer period for its entry into force. Sometimes it can take up to decades for a state to approve and ratify international treaties, agreements, or conventions. And of course, this means that a longer term perspective should be adopted in terms of such a legal instrument seeing the light of day and it's being implemented. That is why this point is also linked to a substantive matter, namely the fact that the current negotiations of a new legal instrument should be geared toward not only towards COVID-19, which is what we're currently living through, but also to any future pandemic, because this precisely the goal of any new legal instrument should keep a longer term perspective in mind, considering how long the negotiations will be, how long it will take for the new legal instrument to enter into force. And indeed, in my own perspective, the wisest approach will be to also envisage events that may currently be not be so immediately foreseeable, but nevertheless that could give this potential new legal instrument any chance at having a longer term impact, because we're in this for the long run, unfortunately. And lastly, but certainly not least, because this is also a possibility, soft law is still on the table as a fail-safe mechanism, as a fail-safe option in case no full consensus is reached or not a sufficient degree of consensus is reached on the need to create a new legal instrument and what it will contain, especially what it will contain. Because the Constitution of the WHO itself foresees the possibility to create legally non-binding recommendations through the World Health Assembly, and that's actually the daily bread of the WHO's work, and mostly operates and acts through legally non-binding decisions, resolutions, and so on. And this will particularly be an open option in case there is no consensus on a new instrument. Article 23 of the Constitution of the WHO grants the Assembly the authority as well to make recommendations with respect to any matter. So similarly to Article 19, the list of issues in which it can give recommendation is quite open, but it goes without saying that resorting to this option will be a major disappointment for all of those hoping for a stronger a stronger role for international law in pandemic preparedness and response. We should keep in mind as well that this would not be an this will not be a new phenomenon. So the fact that we end up with soft law instead of a legally binding instrument would not be unheard of in the history of the World Health Organization. It has happened in the past. You see, in the 1980s, when there were discussions on a potential new legal instrument on marketing of breast milk substitutes, it was decided that this would be addressed through soft law and not through a legally binding instrument, precisely because sufficient consensus was not achieved. And we can now say it quite clearly, this was also the result of lobbying by the food industry, which was opposing any strong stance, any strong measure being taken at the international level in order to regulate how breast milk substitutes are marketed in multiple countries. So we should keep an eye on these historical examples to realize the difficulties that lie ahead in the upcoming negotiation processes, and the fact that there's always the possibility that we may end up with a soft law instrument. And again, of course, this will be regrettable for many of us, but nevertheless, we should at least be realistic in looking back and seeing how this has happened already in the history of the World Health Organization. And the discussion will continue for sure. And considering how today I decided to avoid the many thorny issues that underlie the substantive part of a new legal instrument, so what the potential contents could be and what are the main topics that are being discussed. In a future presentation, I will mention some of them, and I can assure you time will not be enough to cover all of them. But meanwhile, I will invite all of you to check out our final report of the online symposium on international pandemic lawmaking, conceptual and practical issues, which was hosted by the Verfassungsblog and the Bill of Health. And it was coordinated by Alicia Eliyamin from Harvard University, Joel Grogram from Middlesex University London, and myself. And the final report is available open access for everybody to consult. And please check the websites of the Verfassungsblog and Bill of Health for the corresponding link. And in there, you will already have a look at how convoluted and how really heated the debates are regarding some of the major issues that we have seen throughout this pandemic. And all of these points will inevitably be raised during the upcoming negotiations of the intergovernmental negotiating body, which is a member state-led body. And nevertheless, we consider that should you have further interest in the subject matter, our final report can be quite useful in guiding you through some of the many thorny issues that we will see in the upcoming years of negotiations. Without further details and without further shameless self-promotion, I thank you very much for your attention, and I, of course, would welcome any comments, suggestions, or even criticisms regarding today's presentation. Thank you very much for your attention.